Good morning. Today I'm going to look at an interesting case in relation to relief against forfeiture of a lease. Now, this of course is a topic that arises virtually every day of the week. The tenant defaults either in terms of paying the rent or perhaps with respect to a non-rent covenant, and the landlord then re-enters. Different rules of course apply if it's a rent covenant as opposed to a non-rent covenant, but we won't look at that today. We'll look at the general position in terms of getting relief against forfeiture if the tenant has failed to pay rent and rent's been demanded under the lease. And we'll do so in the context of a very recent decision by Justice Robb of the Equity Division of the Supreme Court of New South Wales in a case called Kofoo, I think it is, Kofoo Sussex Property Limited and Commerce Building Property Limited, 2014 NSWSC 1079, decision in early August. And in a sense it's a bread and butter garden variety type of decision. Restaurant's running a Korean restaurant, rent is in arrears, landlord decides to re-enter, does so for non-payment of rent, and then re-lets the premises. And an interesting question we'll need to look at briefly is whether or not the fact of re-letting automatically precludes the relief against forfeiture being granted by the court. And I think it's fair to say in this case it's Justice Robb, Robb, well-known commercial lawyer in his day at the bar, of course, takes a measured and pragmatic view about the commerciality of simply permitting relief against forfeiture. As a matter of pure equity, the lease, in a general sense, is meant to stand simply as security for the rent, in the broader sense, and therefore it's unconscionable if in fact the landlord extends his legal entitlements under the lease and completely forfeits the lease, if in fact it's possible to get back the money which is payable in terms of arrears of rent. That's the usual starting position. There's always a discretion in the court whether or not to grant relief, and if we look at the cases which Justice Robb discusses in some detail from paragraph 111 onwards, he points out that there is such a discretion, and he picks up the decision of Justice Campbell sitting in the trial division before he went on to the Court of Appeal in a case called Wilkinson and S&S GICAS, G-I-K-A-S, which is a 2006 NSWSC 1314, and is actually reported in the Butterworth Property Reports 2006-12 BPR 23685. And in that case, Joe Campbell said that the granting of relief against forfeiture is discretionary. In relation to a lease, the principle that is generally applied is that the power to re-enter or forfeit for non-payment of rent is regarded as being in substance a security for the rent. Provided the lessor and other persons concerned can be put in the same position as before the forfeiture or re-entry, the court will usually grant relief against forfeiture upon payment of rent, costs, interests and other expenses. And Justice Campbell in his turn refers to what is, I suppose, the leading New South Wales case, Justice Hope, Robert Marsden Hope, in a case called Pioneer Quarries, Sydney and Permanent Trustee, 1972 Butterworth Property Reports 9562. And as Justice Campbell says, supported or cited by Robb, if terms are offered, it is only in a rare case that the court would refuse relief against forfeiture. The principle on which that is done is that once the landlord has got all that the right of a re-entry was, in equity's eyes, security, it would be unconscionable for the landlord to insist on its legal right to re-enter. So, usual position is that provided the rent is paid and guaranteed to be paid in the future, and then the tenant can get back in, not as a right, but as a matter, I suppose one might say, of almost automatic discretion. But there may be rare cases, as he points out, where the tenant is unable to pay future rent, or may reasonably be expected to become so. And we've got a couple of Victorian cases, but look at that. And if, as Justice Campbell says, there is a sufficiently serious risk the tenant will not be able to perform its obligations in the future, it may be with the consequences that it is not unconscionable for the landlord to insist on its strict legal right. Now, that's because if you can't be sure that the rent's going to be paid, then in the worst case, as against the liquidator of the company, it may be, for example, that rent which has been paid and received is then recovered or recoverable as a preference, as against the landlord has released the premises. So that is an issue. Now, Professor Peter Butt, leading academic authority in this area, look at his landlord book, 6th edition, 2010. Great book, Peter Butt, great academic years. He discusses the whole area at paragraphs 15.218 through to 15.225. And I think it's fair to say that he takes a broader view in terms of whether or not relief is available. Perhaps not quite so strict as what Steve Robb says is in fact the proper position. Now in this case, there wasn't any comprehensive evidence to suggest that the tenant in default would actually be able to pay the continuing rent. And that raised a bit of an issue in terms of conditions which had to be applied. We're only dealing with a $2 company here, good old Kofoo Sussex with its Korean restaurant. And so there were various conditions applied with respect to the onward payment of the rent. And Justice Roberts says in paragraph 134, in terms of confidence with respect to future rent being paid, that uninstructed by authority, I would incline to the view that there is no single formulation of a test for the requisite degree of confidence, but the lessee will be able to pay rent in the future, which can be adequately described in all situations. Perhaps if the issue is whether relief against forfeiture should be granted in relation to a residential lease, upon which a lessee and his family is dependent for accommodation, the court might not be stringent in what it requires to be satisfied. They'll most probably pay rent. However, this is the key point, and this is the usual case, because the residential area is covered, of course, by a completely different statutory regime. Commercial premises are not. In the present commercial context, the approach is not very attractive. Why should it be that the court should grant relief against forfeiture to a commercial lessee, where the lessee is not hopelessly insolvent, but the capacity of a lessee to pay rent in the future will depend upon a wing and a prayer? Good question. Why should the lessor be dependent on just a mere hope, I suppose, that the money is going to be paid in the future? There needs to be a bit more assurance than that, one might think. And his Honour then looks at various cases discussing a situation where the tenant is hopelessly insolvent. He also discusses an important Western Australian case, Justice Beach, in a decision of Twinside Proprietary Limited and Phoenician Nominees, 2008, WASC 110, paragraphs 36 through to 38, and there His Honour in Western Australia discussed the position with respect to whether or not relief could be granted, or whether relief should be expected to be granted. Now in this particular case there was a problem, because as I said, there had been a new tenancy granted, and Justice Robb looked at that and also said this in paragraph 139. He said this, it's quite interesting. He said, it may be said of the equity to relieve against forfeiture that it is a relatively robust equity. It is available to protect defaulters and survives proof of a propensity to default. It is not particularly solicitous of the interests of third parties, unless third parties acquire a leasehold interest in the property with no actual or constructive notice that a prior lessee may have a right to apply for relief against forfeiture, even though the prior lessee may not have acted in an expeditious way to obtain the relief. But the availability of the relief remains an established doctrine of equity. Little knowledge of the circumstances that have existed over previous centuries in England is required in order to understand the reasons for the development of the equity. It remains attractive in the modern world as it provides succour to the susceptible lessees who are down on their luck. However, there is a case to be made that equity should think carefully about how the doctrine is to be applied in truly commercial contexts. Now, that would be the usual case, of course. Why is that? Well, because in a commercial context, there's likely to be considerable competition for the right to enjoy the property. And that, of course, was the case here. In this case, there had been default, rent not paid, there had been requests and negotiations for payment to be made, then lockout, and then the landlord relets the premises. And the fact is that the commercial reality in that sort of situation is that both the prospective lessor and lessee, in the course of negotiating the terms of a lease and entering into the lease on particular terms, focus primarily on the quality of a lease as a contract. Right? We've had this in lots and lots of cases. A lease is an estate in land, it's a chattel reel, all sorts of interesting property questions arise, it's registrable if it's long enough under the Real Property Act or the Land Titles Act, but the question is, it's also a contract. And so what about the contractual aspect? We won't look at it today, but there's no doubt that over the last 10 to 15 years the courts have been focusing a lot on the contractual aspect of the lease. And as Justice Robb says at paragraph 140, a deal is a deal. Yet in the final analysis, equity in making relief against forfeiture ignores the deal. So be it. But insofar as the court has a discretion in making an order that relieves against forfeiture, there may be circumstances where the court should act firmly rather than indulgently in relation to the conduct of the lessee. Right, so His Honour seems to be saying that in the modern commercial context we've got a bit more of a balancing than simply turning up and offering to pay the rent and guarantee it and get back in. And Justice Robb says at paragraph 141, there may be cases where the public good that flows from holding parties to their bargains and creating a general expectation that will occur will outweigh the beneficial consequences of protecting defaulting lessees. There is a case for concluding that that approach should be given some weight in the present circumstances. The reason is that the court should not facilitate the possibility that the commercial value to the lessor or the ownership of the property is stultified by the practical impediments to the lessor being able safely and effectively to release the property. The specific source of the problem is the probability that in cases such as the present, where the lessor has lawfully terminated a long-term lease by re-entry and locking out, the lessee, all prospective new tenants will have actual constructive notice of the forfeiture, and thus the potential for the lessee to seek relief against forfeiture. So as a matter of equity, the tenant who comes in after an event of forfeiture, if he, she or it has actual constructive knowledge of the underlying equity available to the former lessee who's been locked out, they will take with notice, and therefore their position will be subject to the right of the grant of a new lease, which is what occurs when relief against forfeiture is granted. And Justice Robb points out, as a practical matter of course, that will happen because the lessor, out of prudence or decency, tells his prospective lessees, or it is obvious following inspection from the state of the premises or constructive notice arises from an inspection of the register concerning the title of the property. Well, anyone wandering up Oxford Street in these sad times in Sydney would see a large number of places where there's obviously been a lockout. If you wander down from Centennial Park, as I do sometimes, down into the city, you will find lots of doors that are locked. Sometimes as a formal notice, the landlord has re-entered. Often the telltale sign will be lots of letters of demand and other bank documents lying in the on the floor of the premises, deserted and unoccupied. That'll give you some sort of idea, I guess, that there's been a re-entry. So, the fact that if you're wanting to release the premises is commercial, it's likely to cause confusion and weaken the legitimate bargaining position of the lessor if it cannot safely offer a new lease to a prospective lessee without the position being clouded by the unrealised right of the former lessee to seek relief against forfeiture. Lovely way of putting it, isn't it? Clouded by the unrealised right of the former lessee. It's a bit of a blot on the title, but it's not quantifiable. It's just the fact that he may turn up and seek relief from the court. The existence of this uncertainty in this area will often avail no one. An impediment to the timely and effective re-letting of the premises, and is likely to increase the damage payable by the former lessee. Well, that's true. If there's a breach of the contract of lease and there's some damages flowing from it, the lessor sues, that will increase the damages. And if the former lessee cannot pay those damages, the loss suffered by the lessor will be increased. It's likely to be the case, of course, if the lease is terminated, because you won't be able to get back into re-let. In the real world, the costs and inconvenience that the lessor and the lessee suffer when relief against forfeiture is given will not be entirely covered by the conditions upon which the order is made, as the court does not contemplate an inquiry into the internal costs of either party or the opportunity costs of the exercise. Well, very pragmatic approach there, of course. His Honour's really saying that even if you get back in after some time, the actual costs which you've lost because the premises are unlet, you're not getting any rent, etc, etc, etc. None of those are subject to an inquiry in equity, and one infers from what His Honour says that even if there were such an inquiry, you wouldn't get the money back. So, a difficult position, isn't it? You're balancing it out, and you've got a number of points. First of all, you've got a discretion, not a right to get back in, if you can repay the rent. But even so, it seems now, with the contractualisation of a leasehold interest, that there should be some a bit more reasoned, a bit more nuanced view taken, I guess, of the position. And in this case, His Honour looked then, in terms of discretion, at granting relief, and he looks at that from paragraphs 152 onwards. He notes that the lease was terminated with 8.5 years left to run on it, and therefore it was a potentially valuable asset to Kofoo Sussex. And an offer had been made by Kofoo to pay, and various guarantees suggested, and it's a question, of course, of whether or not, even if it was entitled to relief, whether or not its delay in coming along disentitled it to it. And there's also an offer to reinstate here with a bank guarantee. And in the ultimate result, His Honour concluded that the outcome of the proceedings may be regarded by the defendants as being unfortunate. That's because he did in fact grant relief on terms to be agreed or directed, but he thought throughout that the landlord had acted in an entirely proper manner, often showing considerable indulgence towards the plaintiff. And in particular, the agent had acted in a very professional manner, was obviously a candid witness. So, and also the incoming new lessee was entirely innocent but caught up. So, in the end, balancing exercise, I think they just scrape over the line by reading between the lines in the judgment, but a very useful and important judgment, I think, for all property lawyers, because it demonstrates at the trial division that the court is considering the whole subject matter in the round. In the very old days, probably 15-20 years ago, it was almost a matter of right to turn up, offer to pay and get back in. Now it would seem that the court is far more circumspect about whether or not to grant relief, and is also fully cognizant of the fact that there will be lots of commercial issues which arise, which won't be adequately compensated by the mere payment of the back rent and the provision of a guarantee. So have a look at that case. It's always useful. Equity Division, I guess, is handling these cases week by week. If you come before Justice Robb or one of his brother or sister judges there, this will be a good decision to have at your fingertips, as well as, of course, Pioneer Quarries, Justice Hope, which if you put that into the Austlii search, you'll get about 8,000 strikes. So have a look at the decision and consider its implications closely.